How can that be? How can he make a statement like that? How can he put that in writing? We've already shown that a court order did exist. It was a default judgment. And yes, that is a court order. And we even have the court order number. Then we have a letter from the state saying that that has been set aside and dismissed because it was illegal. But yet he says, didn't exist. Did Attorney Dwyer forget intentionally that an illegal judgment order did exist until it was vacated on 4/6/09? Did Attorney Dwyer conveniently forget that petitioner received a letter from D.N. Finney, a caseworker out of Jefferson City, Missouri, demanding $324 a month, and this was based on court order number 0922 AD 00020? How can she be demanding $324 if there wasn't a court order? And how could she be referring to a court order number when, according to Attorney Dwyer, doesn't exist? There was no such thing. Somebody's lying. Please drop down to number 5, same page of the finding of fact, where Attorney Dwyer states, the child of the order. Excuse me? Would this be the order that didn't exist? What order are you referring to? The child of the order stated, the child of the order has lived with her grandmother continually since October of 2008. Does anybody see what's happening here? He's basically just contradicted himself. There was no order, but the order stated that did live with her grandmother. Well, gee, how can an order state that if there was no order? Obviously there was an order. Anyway, I'm just trying to show these people they don't know what they're doing, and when they get backed into a corner, they just make it up as they're going along. Number 16. Is it petitioner, or can the court see that these people are hanging themselves with their own rope? In one sentence there is not an order, in the next sentence there is. In one sentence they state there is no collusion, and then testimony to the contrary is in the next sentence. If it smells like crim and falsy, looks like crim and falsy, sounds like crim and falsy, then it must be crim and falsy. And again, remember that that's fraud against the court. That's lying to the court. Petitioner also states that perjury is evident. Perjury is testifying falsely under oath concerning any matter material to the issue or cause in question in any judicial proceeding. One who testifies positively on a point as to which he is ignorant is guilty of the crime of perjury, whether the statements he makes be true or false. For the gist of the crime is a willful attempt to mislead the court. Now, don't you remember me telling you that she signed an application saying that she had control and custody of both children? I'm going to dig that out and show you where it says that exactly. Do you have control and custody of both children? Yes. Is his father alive or dead? He's dead. She should have said, I don't know. But this just shows her willingness to lie about anything. Everything on that application except the date of the application is basically a lie. And I said this a million times, but no, gee, we don't care. No. If she says your dad's dead, he must be dead. Well, then during the hearing when I brought this out, she said, well, gee, I'm sorry, I didn't know. Well, gee, if you didn't know, then that's what you should have said. And you said on the application that I had never paid child support, but I paid child support for 5 years, on time, every month. And I paid you child support 7 months after we were married. And it was your obligation to call them and tell them that we were married. But you didn't. All lies. And now when I bring it up to the court-appointed hearing officer, and I bring it up to the caseworker, oh, well, gee, that's not our job. Gee, we're not here to figure out whether she's lying. You're not? Then why are we having this hearing? What is due process? What's this hearing for? What do you mean you have no legal or moral obligation to turn in welfare fraud to the investigative unit. Well, if it's not your obligation, whose obligation is it? Mine? If you won't believe me, then why would they believe me? Number 17, petitioner states that if the caseworkers, the plaintiff, Leah Stamps Jordan, and attorney Dwyer cannot get their story straight, which is perjury, then the doctrine of crimen falsi and perjury is apparent. Another action by all of the participants in the hearing on 3/12/09 against petitioner Michael Jordan, that's me, attorney Dwyer should be disqualified because he tried to injuriously affect the administration of justice. You've heard it called obstruction of justice. You can call it a lot of different things. Fraud against the court. It all comes down to the same thing. He's making it up as he goes along. He leaves out this. If it makes the state looks bad, he leaves it out. Examples of crimen falsi include forgery, suppression of testimony. Remember my request to question the grandmother? I was not allowed to. That's suppression of testimony. He should lose his license to practice law. He should go to jail. But it's not going to happen, people. And I'll tell you why it's not going to happen later. If you hang on, I'm going to tell you the reasons why nobody's going to go to prison except me. Petitioner stated in letters to caseworkers Wooten and Corrales that grandmother had control and custody of Morgan Stamps, and petitioner requested her presence at the hearing, but attorney Dwyer stated he was unaware. But he received the same complaints letters that I sent to the caseworkers. So there you go. Well, gee, I didn't see them. Gee, oh gosh, I didn't know. Well, you should have known. They were sent to you. If you didn't read them, that's your problem. Attorney Dwyer states that no collusion occurred, no perjury occurred, and no subordination of perjury occurred. No subordination of perjury occurred. But the facts tell a different story. Facts that attorney Dwyer deliberately omitted are twisted to defraud the court. Number 18, attorney Dwyer states on page 5, paragraph 2, you can read this later, I'm just going to cut to it. Basically, he stated that it didn't matter whether it was St. Louis City or St. Louis County. Well, yes, it does matter because you didn't have proper venue, which is just another reason why this whole thing should have been thrown out, because you wouldn't listen. You didn't have proper venue. You're filing court orders in a jurisdiction that doesn't have jurisdictional authority over me. So if you're going to do it, at least do it right. Number 19. Attorney Dwyer changes the court order, the illegal one, that said I should pay $324 for 2 children. He changed that to $471 for 1 child. Now, this is violating another constitutional guarantee called ex post facto. Please look it up in your law dictionary or on Wikipedia. Attorney Dwyer's decision, this would be the 5th time that my constitutional rights have been violated, was after an order that had already been established. Every law that aggravates a crime or makes it greater, and in this case it made the order to pay $147 more than what had already been established. Every law that changes and inflicts a greater punishment, every law that alters the legal rules of evidence. Do you remember? Have you already forgotten? Suppressing evidence, perjury, crimen falsi. Have you forgotten those already, or are you keeping up with me? All those things, you cannot change what has already been done. They already said, gee, based on our evidence, you should pay $324 a month. He comes along, and after hearing evidence that I provide to show that there's perjury going on, all kinds of things going on, he says, yeah, you're right. I'm going to kick it up to $471 for 1 because we can't come after you. We can't come after you for 2 children per the law. So I'm just going to kick it up to $471. And he says that this is based on a order that was established by the Supreme Court of Missouri on December the 8th of 2008, and that the caseworkers wouldn't have been aware of when they issued the responsibility letter. Well, excuse me, people, that's what ex post facto is about. On November 24th, they sat down and, based on the information provided to them, said, hey, your obligation's $324 a month for 2 children. I came back around on March and said, hey, she doesn't have control and custody of 2 children, therefore she's not entitled to $324. You agreed with that, but then you said, oh, I'm going to bump it up to $471 for 1 child, and therefore you basically violated ex post facto. You made the crime greater than what it was on November 24th. You inflicted more punishment on me than what I would have gotten if I'd have just accepted the November 24th letter of responsibility. Number 20. Recently, Family Support has contacted petitioner regarding an approved modification agreement, modifying the support order from 471 to 376. Ms. Love, who is a caseworker, stated that the petitioner must agree to the modification in writing. So they are trying to have petitioner served by a process server. Petitioner is confused. He never agreed to 324, the original support order, nor did he agree to 471, the second order by Attorney Dwyer, based on the hearing, nor did he sign any written document agreeing to the suspension of his driver's license, which happened on July 20th, 2009, while I was waiting for the court to listen to my appeal, which I'm supposedly supposed to get based on due process and my constitutional rights. According to Missouri statutes, petitioner is barred from asking for modification for 3 years from the order issued by Attorney Dwyer on 3/12/09. Excuse me. According to the modification form and letter petitioner received, approximately 7/28/09, the letter stated that somebody, petitioner assumes it was the court, asked for modification, and the letter went on to say that they would modify it with or without my consent or information. So did you get what I just said there, people? I get a call from a caseworker who says, oh, we've got to have you sign these written documents for this modification to go through. Was that true? Because according to the letter that they sent me, it says we're going to do this with or without you. Whether you fill this out or you don't. We're going to modify this because someone has asked us. I can't ask him. I don't know who it was that asked them. I assume it was the court, the St. Louis County Court, but I don't know. They didn't tell me. But I can't ask them. But yet, they said, oh, it's important that you sign these papers that we're trying to have served on you. And I said, I'm not doing that. I said, this is bogus. I said, you didn't come to me and ask me to sign papers the other 2 times, but now all of a sudden it's important that I sign. I said, no, you're pulling some kind of scam here. I said, you're wanting to serve process on me to go to court. You're not interested in modification. So anyway, number 21, the Director, Family Support Division in the state of Missouri did commit an overt act. She did basically violate my constitutional rights under the Constitution when she did suspend my driver's license. She did this without going to a court. She did this before my appeal to the court had been decided. She just arbitrarily said, hey, you're not acting quick enough to suit us, and oh, you're writing all these letters, and you're really bugging us, so I'm just going to take and suspend your license. When I called the director, when I called the Missouri Department of Revenue and told them, they said, well, yeah, we received a letter from her saying that we were to suspend your license.